Okay, we've got criminal law and procedure in business. Let's get started with this topic. Okay, so we have this difference between criminal law and civil law. We talked a little bit about civil law, we talked about torts, and they're designed to compensate parties, including businesses, for damages resulting from another's conduct. So we talked about slip and fall. We talked about other parties who are negligent and their negligent conduct, right? The breach of that duty causes some kind of harm. That all falls under civil law. Then we have criminal statutes, and what do they protect? They protect society as a whole. And the violation of a criminal law results in a penalty to the violator. Okay, so there could be fine, there could be imprisonment. They're not mutually exclusive. So that means a person can violate a criminal law and can commit a civil wrong at the same time. So let's say an individual stole personal property and damaged it in the process. Well, they could be convicted of the crime of theft, but there is also a civil law, a tort called conversion that they may also be responsible for. So there could be theft, robbery, let's just say that type, and then also a civil law conversion based on the same set of facts. Okay, so we have classifications of crimes. And when we look at those classifications of crimes, we are looking at what the penalties are. So in a crime that generally carries 1 year or more of incarceration as the penalty, that would be considered a felony versus a misdemeanor, which is a crime which tends to be somewhat of a more minor crime, carrying up to 1 year of incarceration. So that's less incarceration time for a misdemeanor. There's also summary offenses or infraction offenses, which may not be considered a misdemeanor. It may not rise to that level. There may be no threat of jail time for first offenders. Okay, so it could be underage alcohol use and other types of summary offenses that you may see. Okay, crimes in the business world, though, although there can be violent crimes in the business world, they don't always involve force or violence. So, when you are watching movies, you may see, criminal activity, and there may be physical activity, guns blazing, chases going on, things like that. Doesn't always look like that in the business world. These kinds of crimes may occur in an office, over the telephone, through computer systems, emails, chats, things like that. They could take place in restaurants, in bars, right? Different kinds of communications that may end up resulting in some kind of business criminal activity. So, crimes in the business world, we're not always seeing that force and violence. So, who can be liable for a crime in the business world? So, of course, the individuals who partook in the criminal activity could be liable, they could be on the hook. But in addition to that, the company itself, the corporation, if it's a corporation, the business itself could also be responsible in addition to its principals and its agents. Okay, white collar criminal activity. So typically, this involves non-violent crime committed for financial gain. Okay, it could be by a business, it could be against a business. And these kinds of crimes are called white collar crime because I'm sure you can guess why. White collars, dress shirts worn by people within a business. So these include a number of different kinds of crimes, and some examples are fraud, bribery, theft, and conspiracy. These can be state crimes, so there's state statutes governing these. They can also be federal crimes. So, white collar crimes, just like some of the other crimes we talked about, may be felonies, they may be misdemeanors, and we'll talk about specific types of white collar criminal activity. The first being fraud, right? So, the basic elements of criminal fraud are listed here, right? A false representation. We also talked about this type of activity in the torts context. false representation or concealment, so the failure to provide certain information concerning a material fact, something that is essential to an agreement or one that affects the value of a transaction. So it has to be material, it has to be essential, very important information that was falsely represented or that was not provided, it was concealed. And another party has to rely on the false misrepresentation and suffer damages as a result. So in your book, we can look at a case example here, and it actually is a case, and the facts come out of Philadelphia, so not too far from us. And this is on page 769. It's case summary 22.6. You can see this here. So we've got this former dean of the Fox School of Business at Temple University, and he was convicted in the Eastern District of Pennsylvania for submitting fake data to the U.S. News and World Report. And as some of you might know, the U.S. News and World Report compiles data that's provided by educational institutions, and they provide a ranking system, including those educational institutions. Okay, so he provides this fake data about the business school's online MBA and part-time MBA programs. So the U.S. News Report, U.S. News and World Report used this fake data. They didn't make any effort to independently verify or audit, and this information was included in the school rankings. And this school, this Fox School of Business, moved from number 25 on the list to number 1 based on this false information that was provided. So there's a couple questions here, and one is, why wasn't U.S. News and World Report also charged with fraud? Okay, so we know that this former dean was charged with fraud, right? Because he made this false representation concerning material facts, right? So information regarding the business school, and other people, students, relied on the false representation and they suffered damages. But why wasn't U.S. News and World Report on the hook here? They didn't make any effort to audit or otherwise verify the truth. And the reason is because this dean had this intent, right? Knew that this information was false and made these false representations, right? The magazine didn't have this required intent, so was not on the hook for fraud. Okay, next thing is a Ponzi scheme, which is a type of securities fraud. And if anyone can see the bottom here, we have a picture of Bernie Madoff. And Bernie Madoff is pictured here on this Ponzi scheme slide. And the reason is because Bernie Madoff, he was the former chair of NASDAQ. He was the founder of a very successful Wall Street firm. And he, because of his involvement in securities fraud and a Ponzi scheme, was sentenced to 150 years in prison. He was convicted of fraud through his Ponzi scheme that costed investors 65 billion with a B, billion dollars in 2009. So Ponzi schemes, it's a type of securities fraud in which large, very large gains are promised to investors. So investors get very excited when they hear, wow, we can get these huge returns on our investments. So the Ponzi scheme, the person who's running the Ponzi scheme collects this money from these investors so that it can invest the money, or at least that's what it looks like to the investors. But in reality, the newer investments are used to pay the returns to the earlier investors. And the people running the Ponzi schemes are pocketing lots and lots of money. So this system will collapse over time because these required returns to early investors become too large to cover the income from newer investors. So this is a type of white collar crime. So we have this statute called RICO, the Racketeer Influenced and Corrupt Organizations Act. And this was enacted in 1970, and it was designed to bring down organized crime. And it prohibits organizations, their employees, from participating in a pattern of racketeering or illegal acts. So, racketeering is a pattern of illegal scheming and activity for profit. Okay, so extortion we can think of, or coercion, but there's also other types of acts that can fall under racketeering. So it could be illegal gambling, it could be kidnapping, prostitution, and under RICO, it's easier to prosecute corrupt organizations and to seize the illegally obtained assets that were collected through the racketeering activity. So this has been a successful act in helping to bring down organized crime. Okay, insider trading. So you may recognize this lady at the bottom here. This is Martha Stewart, who is famous for many, many reasons. So she had an extremely, actually, she still does run a business, but she's been very successful in being this homemaker extraordinaire with TV shows and magazines and books and product lines and you name it. Um, so she, like many people, invested in a particular company. And at age 61, she resigned from her position as CEO of her company after charges were brought against her. So she was involved in insider trading. So prosecutors charged that in 2001, Stewart was tipped off by her securities broker that this particular company, ImClone, that she invested in, was going to drop after the company's owner received inside information that the FDA, the Food and Drug Administration, was going to decline to review an application for the company's cancer drug. So she said, you know what? I don't want these shares anymore. I know that they're going to go down. So she got rid of nearly 4,000 ImClone shares worth $230,000, which really is probably a little bit of a drop in the bucket compared to the amount of money that she had. So she dropped these shares one day before the FDA decision was announced. And she was found guilty of conspiracy, obstruction, and 2 counts of lying to federal investigators. And she was involved in insider trading. That's what the court found. She maintained her innocence, but the court found otherwise. So, insider trading laws prohibit corporate insiders from trading their company's stock based on their insider knowledge. So, she did have this insider knowledge that was provided by her securities broker that came directly from someone within the ImClone company. So, we have this act that was passed by Congress in 1988, the Insider Trading and Securities Fraud Enforcement Act, which has penalties. It raises the criminal and civil penalties for insider trading, and you can see the additional things it does. The next crime we are going to talk about is bribery. And bribery generally involves a scheme to pay a government official money in order to obtain favorable treatment for a personal or business transaction. Okay, so generally we're talking about a government official who's being bribed. Now, a simple example of what a bribe can look like. Now, this does not rise to the level of criminal activity, but just to see what that may look like is, let's say I go into a restaurant, right? And it is a busy, busy restaurant, and I didn't make a reservation, but I want to eat at this restaurant. So what do? I go up to the hostess. I say, I'd like a table for two. I take a $50 bill out of my purse. I slide it across the hostess stand to the hostess, and the hostess says, please follow me, and grabs 2 menus and takes me and whoever I am dining with that night to the table, right? So the hostess is going against what her job really requires her, and she's giving me favorable treatment, right, in exchange for money. Okay, it's not necessarily a crime. But in the criminal context, a bribery is an offense that requires only the offer of a bribe. So the transaction itself doesn't need to occur. So if I were to bribe a government official, let's say a judge, to get a favorable outcome in a case that I was litigating, right? That judge could decline. The transaction may not actually go through, but the fact that I made the offer of a bribe is in and of itself a crime. So both the giver of the bribe and the receiver may be charged with bribery. So I want to show you this video of a Texas judge, Judge Delgado, that was sentenced to 5 years in prison for bribery.
It first started at the 93rd District Court in Hidalgo County. Then it moved to the home of 93rd District Court Judge Rudy Delgado. 2 FBI raids led to the arrest of Judge Delgado, who spent the weekend behind bars. The judge was released just a few hours ago, and our cameras were rolling as he left the federal court this afternoon. CBS 4's Jelani Martinez is live in McAllen to pick up our continuing coverage. Jelani.
Nicole, 93rd State District Court Judge Rodolfo Rudy Delgado has been released on a $100,000 bond after he was arrested on Friday on bribery charges. According to the criminal complaint, the investigation by the FBI against Delgado began in November 2016. The complaint states that Delgado allegedly accepted bribes in exchange for favorable judicial consideration on cases pending in his courtroom. The FBI used a confidential informant, a Texas attorney who confessed of bribing Delgado all the way back to 2008. The complaint goes on to state that on January 17th this year, the FBI set up an undercover investigation where the confidential source was equipped with audio and video recording devices. The FBI recorded a phone call where the source made plans to meet Delgado at a restaurant. When meeting up with Delgado, the source stated that he or she had cash for him and in exchange needed Delgado's help on a case where a client had a pending motion to revoke. According to the criminal complaint, Delgado allegedly acknowledged and accepted the money. On the following day, according to the complaint, Delgado placed the confidential source's client on bond. Outside the federal courthouse this afternoon, when asked if he would return to the bench, Delgado said,
I don't know how to answer that, as there are other authorities that may have a say in that as well.
According to the criminal complaint, the FBI says that they believe Delgado was trying to cover up the bribe after he contacted the source about a week later, stating that the campaign.
So another crime that we want to be aware of is obstruction of justice, right? So obstruction of justice, if there is conduct related to attempting to cover up evidence of wrongdoing, right? It's interfering with the ability to find justice or to result in justice in some sort of proceeding or process. That could be the crime of obstruction of justice. So it can take different forms. Here are some examples here. So lying to investigators, right? Changing documents, right? When you're supposed to provide certain documents and you alter them in some way. Shredding or concealing documents or any media such as videotape. Inducing, right, influencing witnesses to lie or to refrain from cooperating with authorities. So here is an example here of this famous case that we talk about when we are within this area of obstruction of justice. It's in your book, and it has to do with Arthur Andersen. And Enron was a very successful corporation at one time, and it encountered certain financial difficulties which became public. And Arthur Andersen, who was the auditor for Enron, instructed its employees to destroy documents. And this was pursuant to an established document retention policy. So companies often have these document retention policies, which set out how long documents should be kept, when they should be destroyed, how they should be destroyed, how the determinations are made with regard to retention or destruction. So Anderson was indicted under a federal statute, and the federal statute makes it a crime to knowingly, corruptly persuade another person, and so on and so forth, to destroy, alter documents when there's an official proceeding. So the jury found a guilty verdict for Arthur Anderson. The Fifth Circuit Court of Appeals, the court received the appeal. They affirmed the decision, finding Anderson guilty, holding that the district court's jury instructions properly conveyed the meaning of corruptively persuade, and the jury didn't need to find any consciousness of wrongdoing, any intent in order to convict. So the issue, which was determined by the U.S. Supreme Court, was whether the jury needed to find consciousness of wrongdoing in order to convict Anderson. Did they need to have this intent factor? And in a unanimous decision, the U.S. Supreme Court overturned Anderson's conviction and reasoned that the instructions allowed the jury to convict Anderson without proving that the firm knew it had broken the law, right? So the firm didn't necessarily even know it had broken the law, or that there had been a link to any official proceeding that prohibited the destruction of documents. So it looked at that consciousness of wrongdoing, and it said that Anderson didn't show that. All right, so now just be aware that there is this Computer Fraud and Abuse Act, and it was created in 1983. It was amended in 2001, and it makes it a federal crime to access a protected computer without proper authorization. So there are a number of different kinds of crimes that fall within the Computer Fraud and Abuse Act. You can look at them here: accessing unauthorized information, trafficking in passwords, fraud by computer, and other types of computer-related fraud and abuse. And there's penalties, criminal penalties, and civil actions to recover damages under the Act. And it allows the government to prosecute individuals who hack into computer systems of the government and of business entities. All right, so criminal procedure, right? This is a section of your chapter. There's legal safeguards to protect the rights of individuals. They're primarily provided by the U.S. Constitution's Bill of Rights. Okay, so for searches and seizures, I'd like you to watch this PBS video, which will be posted on the course webpage. And I think it gives a good overview of the law regarding search and seizure. Be aware that a very important issue now, because everyone has an electronic device, is the extent to which electronic devices like cell phones fit into current law of unlawful search and seizure as defined by the Fourth Amendment. And a case that is of utmost importance in this area of law is Riley versus California, which is a Supreme Court, U.S. Supreme Court decision from 2014. And in this particular case, Riley was stopped for a traffic violation, and it eventually led to his arrest. There were 2 loaded handguns that were found under the seat of his car. So at the police station, they were examining Riley's cell phone, and the state charged him with attempted murder based on what they found on the cell phone. So Riley moved to suppress all the evidence that the police had obtained from his cell phone. They claimed that it violated his Fourth Amendment right and the warrant requirement. The Supreme Court in this case unanimously ruled that law enforcement must obtain a warrant before searching the digital contents of a cell phone seized during an arrest. So the Supreme Court reversed the decision of the lower courts and they ruled in favor of Riley. So it required, the court held that the digital era required a rule that individuals have a high level of expectation of privacy in their cell phones. People store a very large quantity of information, some of it's very personal, and no person would ever have on them hard copies of all of this vast amount of information. And therefore, to be able to search someone's cell phone, there is a warrant requirement.